welcome everyone to the webinar Advancing Civic Space and Media Freedom through Anti-SLAPP's Legislation. I am Carina. I work in the Europe regional team at Open Government Partnership, and today's event is organized together with the European Centre for Not-for-Profit Law and the wider coalition against SLAPPs in Europe, or the CASE coalition. You will have the pleasure to hear from quite a few members of this coalition. And this webinar, for your knowledge, is organized in the framework of OGP Europe Dialogues, a series that is designed for the European open government community, aiming to connect the EU and wider European regional policy priorities with national OGP processes and stakeholders. So once again, you will have the instructions on how to access interpretation throughout this webinar. This will also be available in the chat, so feel free to use it. What to expect from today? Today, we will hear a testimony of what it means to be on the receiving end of a SLAPP. We will walk through the EU directive on anti-SLAPPs. And then we will look at whether and how SLAPPs have been used and are countered in two different national contexts in the UK and in Poland. And then we close off with looking ahead, especially through the OGP process. Before we really dive into this, though, we want to create a common understanding of what SLAPPs or strategic lawsuits against public participation are. And to do that, I'm now calling on Jessica from Index on Censorship to present us with a couple of examples. So get ready. You also get a chance to vote very soon. Jessica?
Thanks so much, Carina. Are we still using the slides with the examples, or should I just call them out?
Yes, we will use the slides, so you can read them out, and great. People can read them here as well.
Great. Thanks. So, yes, so as you can see, so case one, a woman is assaulted by an acquaintance on a night out. She reports it to the police, but nothing happens. She fears that others could be at risk, so she publishes a post about the assault on social media in order to warn people about him. He sues her for defamation and privacy. So it would be great if you could analyze this case and just get a sense of whether it is a SLAPP. So if you think it's a SLAPP, please vote yes. And if you don't think it's a SLAPP, vote no. Great. So we see that, yeah, the poll has ended. So thanks so much. Carina, should I call out should we leave it to the end and do the full polls, or should I call out the result?
You call the results right away.
Sure, great. So 33% of you think it is a SLAPP and 76% of you thought it wasn't a SLAPP. So it's true that this isn't the typical SLAPP that we've been used to seeing in recent years. Many of the SLAPPs that we've been used to seeing have been around journalists. In the UK, many of them have been journalists targeted by oligarchs. But this is, in fact, a SLAPP. And as we'll see later, there's actually a true story attached to this one. So this is a SLAPP because it is in the public interest. This woman spoke out to warn other women, and she was sued as a result, and it's a public interest case. So it's one of the reasons, that the public interest aspect is a really core area of identifying a SLAPP, and there's many other criteria that we look for, but that's a really important one. So yes, this is in fact a SLAPP, or could be in fact a SLAPP. So we have another case study 2. So a local community group doesn't like the look of a new housing development in their neighbourhood and fears it will reduce the value of their homes. They undertake a public campaign to have it stopped, including by calling out the developer for being corrupt. The developer sues them for defamation. So do you think this is a SLAPP? Once again, please vote. yes, it is a SLAPP, or no, it isn't a SLAPP. Great, so in this case, 55% of you thought yes, it is a SLAPP, and 45% of you said no, it's not a SLAPP. So in this case, again, in these case studies, we're really looking for the core public interest aspect. So in this case, a local community group doesn't like the look of a new housing development. That's not really public interest. They fear as well it will reduce the value of their homes. That's something that's very, I think we could say, is very personal. There's not a there's a private gain there that's not really in the public interest. And they call out the developer for being corrupt, so that by the looks of it, at face value at least, we can assume that the there's no evidence that the developer is corrupt. It looks like they're calling the developer that because of the fact that the value of their homes will reduce. So the developer may very well have a case for suing them for defamation because he's being called because he or she is being corrupt. The company is being called corrupt. So again, on the face value of this, it doesn't seem to have public interest. And so we can assume, just on the very limited information that we have here, that it's not a SLAPP actually. Now that's not to say, of course, there's many cases of developers taking actions against community groups, but usually tends to be on environmental grounds, or public interest grounds around that they might have around environmental concerns. But as I say, at face value here, it looks like this wouldn't qualify as a SLAPP. So we have a third and final case. So in this case, a Swedish journalist is investigating the financial activities of a renewable energy company and sends a few questions to the owner as part of the right to reply process. The journalist receives a reply from his solicitor, so from the business person's solicitor, threatening the journalist with legal action in the UK and in Monaco if they go ahead and publish the story. Is this a SLAPP? Please go ahead and vote. Yes, it is a SLAPP, or no, it's not a SLAPP. Great, thanks everyone. So 21 of you voted and 100% of you answered yes. I'm not totally surprised, because this is very characteristic of the kind of cases, the kind of SLAPP cases that we're used to seeing. This again is based on a true story, which we'll be getting into a little bit later. But yes, it absolutely is a SLAPP. It has the public interest. The journalists were investigating an renewable energy company, and they got legal threats and legal action as a result. So yes, well done. Everyone got this correct. Then Carina, back over to you.
If you wanted to for clarification, also walk us through the definition of SLAPP, so we have a very common understanding. I guess it's as we saw from these cases, it's very we have a very different understanding coming into this webinar of what could constitute a SLAPP.
Yes, that's right. And I think it's good to take account of all of the different types of SLAPPs with all the different public watchdogs that can be targeted. It's not just journalists, as we say. So a SLAPP is an abusive lawsuit filed by a private party with the purpose of silencing critical speech. So as I say, there's some criteria. There's a really great list of criteria in the Council of Europe recommendation, which I'm sure we'll be speaking about plenty more during this seminar. But in the recommendation, you'll see a list of criteria which you can use basically as a checklist. But some of them really important ones here are: firstly, is the legal action brought by a private party, so a business person, an oligarch, someone, as an individual who's trying to silence. Secondly, does the legal action target an act of public participation? So again, is the person, for example, speaking out in the public interest? Are they undertaking a protest? Are they getting people to sign a petition? And thirdly, has the lawsuit been brought with the purpose of silencing, shutting down, or discouraging acts of participation? So that's really important. So those are kind of the key, the three key areas that we look for right at the get-go when we're looking at a case. And as of course, there's lots of many other criteria as well, but that we can delve into. But they're some of the most important ones.
Thanks so much, Jessica. And we will hear from Jessica again in just a little bit. But now we will move on to our testimony. Not only, but of course, open government advocates, right information activists, intermediaries are often major targets of SLAPPs. And this has a very direct effect on their ability to operate, to uncover potential wrongdoing. And this is really the reason why open government partnership, as we are here, we are speaking about this today. Open government cannot function when it cannot be applied to the powerful too. But coming to Antonio, we are very happy that you are with us today. Antonio's role as an activist started already in the 90s in Greenpeace and Amnesty International Italy. Since 2012, Antonio has been with ReCommon, where he is a programs director and works on reforming international development finance. He's a renowned expert on energy, finance, and infrastructure-related issues, has written 4 books, contributed to several publications, and testified at the Italian and European parliaments on sustainable development-related issues. And with all this background, Antonio has unfortunately been on the receiving end of a SLAPP. So to tell us more about why, how this took place, and how it has affected you, please, Antonio, the floor is now yours.
Yes, thank you. Thank you very much for this opportunity, and thanks to the Open Government Partnership and CASE Coalition for the invitation. Will you put up my slides or shall I? Yeah, here we go. So very quickly about ReCommon and who we are. Basically, we are an Italian, an NGO incorporated in Italy, and we primarily work against abuse of power. We are guided by the framework of fighting extractivism, with a particular focus on phasing out fossil fuel economy towards a just transition, and when we run public campaigning on finance corporate actors through investigations, field work, communication, advocacy, and support for impacted community. We have several corporate financial targets, Italian ones, Eni, Snam, main energy fossil companies, Intesa Bank, and such at the moment. Next slide, please. Sorry, just a second, just shifting to my other presentation, just a second. Basically, Eni is one of the largest multinational companies of Italy, is the second largest producer of oil and gas in Africa, the third largest expansionist, is listed in Milan and Wall Street. It's still controlled 30% by the Italian government and the Golden Power rule. So basically, the Treasury can have a strong influence on the shareholder assembly and basically appoints 2/3 of the board and the CEO and the chair of the board. Eni is by far the largest contributor to advertisement in Italy, and I think that the former Prime Minister of Italy, Renzi, in his statement made it very clear that Eni means the energy policy of Italy, the foreign policy of Italy, but also the intelligence and security policy. He clearly said, I mean Secret Service. So this is what some very authoritative journalists define as parallel state. Next slide, please. Now, Eni has been, for the reasons mentioned above, a main target of ReCommon's work because it's a main extractivist actor globally. We regard it as the main blockage to just transition in Italy, but not just in Italy. We did fact-finding missions work in the Niger Delta, in Italy, shareholding activism, innovative communication, community support, And since 2013, we engage the company through strategic litigation, and in particular as concerned a high-profile grand corruption case, so-called OPL 245 license in Nigeria. We filed criminal complaint and basically against Anti-SLAPP. They got on trial in Milan and Abuja. In the end, they got acquitted, despite in 2022, the OECD defined the Milan judgment not conforming with the OECD Anti-Bribery Convention. And in 2023, we filed a pioneer climate litigation together with Greenpeace Italy against Eni. Next slide, please. Next slide. Here we go. Now, since this acquittal that I mentioned, Eni started a very intimidated approach towards ReCommon in particular, openly saying that ReCommon dared to submit a criminal complaint, which ended up into a trial and then acquittal, and also because we tried to be a civil party in the trial. Now, this was an escalation. Just put a very quick timeline. December 2021, they put on public notice the national TV service right not to broadcast an interview on myself concerning the Nigerian case. Since 2021, there were some very strong attacks on right-wing media against ReCommon, backing Eni's argument, exposure of ReCommon financiers, and also our digital system and servers got a serious hacking, which lasted for quite some time in the middle of 2021. In May 2023, there was a strong reaction by Eni targeting specifically ReCommon at the launch of the climate litigation, threatening soon legal action. In July 2023, we got summoned together with Greenpeace to a mandatory mediation process concerning how the climate litigation was communicated, something we rejected. And at the end of 2024, basically we got 2 SLAPPs, one civil and one criminal. Next slide, please. I think it's coming. Here we go. Sorry, just probably some delay from my side. Apologize for that. Basically, we're talking about two cases here, 2 SLAPPs, which are interrelated. The first one is a specific criminal action targeting myself. I got summoned to go to the closest police station on 24th of October, and basically I learned that I was a suspect based on a criminal complaint filed by Eni to the public prosecutor in Rome in June 2024 concerning for alleged defamation via media, and it referred to a 35-second long interview, which was broadcasted within a half-an-hour-long program by the national TV RAI, specifically the program, investigative program, their investigative program report in May 24, regarding the tragic torturing and murdering of the Italian researcher Giulio Regeni in Egypt back in February 2016. And now there is an ongoing case concerning this killing against 4 Egyptian agents in Rome's court. And by the way, Eni CEO will testify in it in late May this year. Now, at the moment, I'm a suspect. I'm waiting for the conclusion of the investigation, expected within 12 months since the opening of the investigation. And very likely also the journalists of RAI are basically under investigation. Next slide, please. So, what is contested are fact-based statements, which were already included in a publication issued two years earlier by ReCommon. And basically, you can read these 2 statements. I basically stated that there was a clear overlap in terms of timing, not in terms of responsibility, between what was happening with Regeni and what Italian diplomacy was doing on one hand, and on the other hand, the fact that Eni was finalizing the negotiation for acquiring the largest ever gas field in the Mediterranean Sea, and got awarded the license just 3 weeks after the body of Regeni was found. And then I stated and recalled that the Scalzi, on behalf of Eni, together with other oil majors, had a key role in basically conceding a lot of credits to Al-Sisi, financial credit, and at the time when he got in power in Egypt, and there was a significant distress in the country economically. So These are facts-based, proven in this report, again, was just like said in 35 seconds. Next slide. Basically, the allegation of any, my lawyer regarded as completely not grounded, very much instrumental just to shift, divert attention away from Regeni's trial and any potential connection with any. And in November 2024, Reportrai investigated further the case and actually produce evidence about how Annie had direct relationship in those days while Regeni was still kidnapped and in jail with at the highest level in the Egyptian government with the prime minister. And while the Italian government wasn't able to get that conversation with LCC government. So again, this is a clear example, in my view, of scaling up intimidation against a representative of ReCommon, and in particular isolating him from media opportunity. Now, what is new in this kind of SLAPP? First of all, there's a shift from the traditional tort cases asking for monetary claims to neutralize financially NGOs towards the personal intimidation of individuals of NGOs on criminal grounds. So this is a clear message to other activists to think twice and to step down if they want to criticize any. Then there is the attempt to isolate sources and the few free voices from the journalists which are willing to report on any, also from a critical perspective. And in Italy, we got a new law in the mid of this year criminalizing also journalists for what they receive from judicial sources. This is also highly problematic. And again, the same route. And then it's fair to say that the traditional use of SLAPPs by any, in particular against journalists, there are more than 4 cases, basically were just like a failure in the sense that any lost in court. Next slide, please. Now, as I said, this is related to a second SLAPP, which was filed in Rome Civil Court against ReCommon and Greenpeace. The same in early October 2024. And this was a response by the company to the climate litigation and the failed mediation. They tried based on allegation of defamation by media. In this case, defamation in Italy is a crime, as well as you can ask damages in civil court, and this is based on extracontractual liability. Now, the first hearing was delayed to June 24th this year because the judge, by the way, wants to understand and see what happens at the Supreme Court, where the climate litigation at the moment is. Concerning the justiciability objection raised by the company. Now, any claims that in a quite bizarre way, in my view, that the lawsuit is not related to climate litigation, despite specifically they contest 3 posts on Facebook, Instagram, and X, launched on the same day of the filing of the summons under the climate litigation and announcing it. So that's very strange because they act in this way as if they couldn't defend in the main trial in court. Next slide. Now, ReCommon in this has a very limited role in, if you read the summons of the case, which had been made public, because it deals just like with 3 posts on social network. 2 of them were withdrawn and just another relaunch of a Greenpeace post. There are more allegations concerning Greenpeace and a specific report they publish against Annie. But it's very interesting that Annie contests the use of the term climate crime in these 3 posts. And however, it's fair to say that in the climate litigation, despite it is a lawsuit, there is a clear reference also to the criminal profile of some of the offenses of Annie, particularly as concerned environmental disaster. And the term climate crime is widely used. I mean, there's an organization funded by former ICC, International Criminal Court prosecutor, called Center for Climate Crime Analysis. There's even a database of the Mid University in Boston on climate crimes. So it's widely used. Next slide, please. Now, why this is a SLAPP? I mean, we think this is a clear intimidation again, and it's a way for Annie to gain some leverage to force NGOs possibly to settle the climate litigation. Annie could easily defend, as I said, within the main case in court. And it's fair to say Annie is very able to influence Italian media much more than us and Greenpeace, and so in any case has more visibility, and that's what has been already used widely against us. And ReCommon even cancelled 2 of the posts, 2 to 3 posts after the summons for the mediation in August 2024. Next slide. So to conclude, what is new in these other forms of lawsuit? Well, Annie is not requesting monetary compensation for damages, but is looking for an injunction from the judge to prohibit ReCommon and Greenpeace to use the term crime in general associated with the company. Now, this is very wide, and you need to think that at the moment, Annie is on trial for environmental disaster, which is a crime under the Italian Penal Code in Potenza Court in southern Italy. And it should be noted that Annie feels reputational risk in claiming direct monetary compensation, because ReCommon and Greenpeace filed the lawsuit, the climate lawsuit, but they're not asking for monetary compensation. And however, Annie is requesting that basically the defendants, in any case, if they are convicted, they published for 3 times large fonts on several mainstream media the judgment against them. So again, this is an indirect way for asking for monetary compensation. And of course, they request also legal expenses. Next slide. And this is the final one. I tried to address this question: what could have helped to prevent SLAPPs? I mean, as I said, there is a real issue with the freedom of media in Italy, I would say, in the sense that corporate influence is very strong. It's not a case that both the climate litigation as well the SLAPPs against us and myself receive much more media coverage abroad than in Italy. Secondly, the parliament hasn't been so active in monitoring and looking into any, and its parallel state, if you like. An active parliament would make the difference, in my view, and offer cover also to critical voices, and I would say a proper dialectic in democracy. Then also, Italian civil society has been intimidated by Annie constantly. Also, some of the groups, they are funded by Annie's foundation, so there are different ways for blocking more critical voices arising from civil society. And again, that's why international support for us has been very important, including yours in hosting us in this event. And finally, probably from a common perspective, a stronger focus on the government's accountability is needed, because again, the company is participated 30% by the state. So that's something very important to consider. I will stop here. I'm very open to take any question from you. Thank you very much.
Thank you, Antonio, for sharing your story. I mean, this there's a lot to unpack here, but what I find really interesting specifically is how this and everything is connected, right? Like if you look at this from an open government policy perspective, we have civic space, how free our civil society and how well supported they are. Then at the same time, we have issues around like media freedom, right? Like that you mentioned are really important here to support you and or that could have prevented this from happening. While we wait, please feel free to add any of your questions in the chat. But I think from my side, in my previous role at Transparency International Estonia, I worked with quite a few whistleblowers. I find that this is, somewhat in a similar way. They are often also hit by SLAPPs or similar. So I just wanted to perhaps ask you how you feel this has influenced you personally, and how you feel that this has influenced the civil society working against these large corporations as a whole. Do you feel that there's been a change because of a case like this?
Yes, I think that there is already an impact. I mean, we can't deny this. Of course, I have to say psychologically it's not, no one is happy to be a suspect under criminal investigation for the wrong reasons. You try to stick and be concentrated and carry on the work. I really think that, as always, all these labs takes, in particular for civil society, a lot of effort, a lot of time spent with lawyers, even further attention to libel checks, whatever you do. So that kind of preventing approach, unfortunately, sometimes does materialize. So you're always angry that so much time is spent on your defense more than actually carrying forward as you would like the rest of the work. This hasn't prevented us to keep campaigning on any. We received quite some large solidarity. And probably, we realize that, as you said, Carina, it's a broader question of democracy when these things happen, so there is always that. I think the important is to balance your personal case, but at the same time raising the broader issue. And we really hope that civil society will engage more on the broader issue. As I said, many people, despite they're sympathetic to us, they're concerned of raising their voice, maybe and raise some criticism about any attitude or behavior. But I really hope that more voices will emerge on the wider problem. So I really hope this is broader lessons, in particularly in the current political context, where I do believe that some fundamental rights are under attack to some forms by the current government in at least. So it is a matter of democracy. I think that's the frame that probably civil society has to adopt, and it has to be smarter in their strategy and mutual support for not stop doing their work. Ultimately, we are watchdogs, and the main aim of the SLAPP is to neutralize us in our role. That's how I live that.
Absolutely. See, there's no questions at this very moment, but we are happy to come back if any questions arise. Thank you so much, Antonio, for sharing this, and really wish you patience and luck in this case. Now we are heading over to talking about kind of more the preventative measures on legislative terms. I'm going to now hand over to Francesca, who is the Senior Legal Advisor at ECNL, to moderate our next segments. Over to you.
Thank you, Carina. Good morning, good afternoon, everyone, wherever you are. So as Carina pointed out, now we have fleshed out what we mean when we talk about SLAPPs, and we have heard the harrowing testimony of their chilling impact on civil society. So what are the instruments now at our disposal to fight back? From the European perspective, in terms of legislation, we are probably all aware about the EU Anti-SLAPP Directive that came into force last year in May. And it's a legally binding instrument, but it's also complemented by other instruments such as the non-binding Council of Europe's recommendation on countering the use of SLAPPs. Now, we would like to hear more about the standards for anti-SLAPP legislations, for anti-SLAPP protection that are set by these instruments, and that should inform, ideally, national anti-SLAPP measures as well. So we have here, for starters, our colleague Emma Bergmans from Free Press Unlimited and Case Coalition. Welcome, Emma. And Emma, just a brief presentation, introduction, is a Senior Policy and Advocacy Advisor at FPU and working to improve the safety of journalists worldwide. But she has also been actively involved in anti-SLAPP work in Europe. She's currently sitting in the steering committee of the Coalition Against SLAPPs in Europe, the CASE. And she also led the FPU's research on SLAPPs specifically in the Netherlands, and therefore chairs the Dutch anti-SLAPP working group. Now, Emma, we are keen to know more about your work within the CASE Coalition, but also as civil society organizations defending fundamental rights ourselves, we all welcome the adoption of this EU directive as a first step into the right direction, and we are very keen to see how it will be put into practice. So can you share with us what your work about CASE is, but also what this specific directive covers and what are its strengths and weaknesses or challenges for implementation? Over to you.
Thanks so much, Francesca. Before we dive into the EU Directive on Anti-SLAPPs, I just wanted to give all of you a brief overview of the Coalition Against SLAPPs in Europe. What do we do? How did we come into existence? And also a little bit of a picture of SLAPPs in Europe. How big is the problem? What are we talking about? So the next slide, please. Yes. think you'll have to click through. Yes. So the CASE Coalition is a broad coalition of more than 110 non-governmental organizations from Europe who are all united in fighting the fight against SLAPPs. It's quite a broad coalition of different organizations, including journalist support organizations like ours, the civil society organizations, human rights defenders, environmental organizations, whistleblower organizations. So it's really a broad coalition of organizations that get faced with SLAPPs or whose target group get faced with SLAPPs. Jessica already explained a little bit what SLAPPs are, but just to briefly recap, SLAPPs are often pursued by wealthy and powerful litigants and are an abuse of the legal system and a real threat to democracy. It's an attempt to intimidate and silence public watchdogs through lengthy and expensive litigation that drains the target's resources and chills critical voices. Through the CASE Coalition, we work to expose legal harassment and intimidation, protect the rights of those who speak out, and advocate for comprehensive protection measures and legal reform. Next slide, please. The CASE Coalition came into existence after the murder on a Maltese investigative journalist, Daphne Caruana Galizia. Daphne was quite a famous investigative journalist in Malta who did a lot of research into corruption and specifically the Panama Papers as well. In 2017, she was murdered by a car bomb. But aside from the fact that she was murdered, she was also facing, at the time of her death, 48 libel suits. When she died, over 30 of those cases were directly transferred to her family, these SLAPP lawsuits. And this was really a watershed moment in Europe and a wake-up call, I think, for many people, where we saw what the impact was of these legal lawsuits to intimidate voices, critical voices. Next slide, please. After the murder on Daphne, and what came out of that, the CASE Coalition was set up with actually three main branches of work. The first one is advocacy, where we try to advance anti-SLAPP solutions on a national and on a regional level, which eventually led successfully to the adoption of the EU Anti-SLAPP Directive. We have a big campaigns branch as well, where we expose SLAPPs and those who use SLAPPs to threaten critical voices. And the third branch of work is legal, where we try to build the resilience of civil society and targets of SLAPPs so they can better defend themselves. Next slide. Just to give you a bit of an overview of what we're talking about when we're talking about SLAPPs in Europe, CASE brought out its newest report end of last year, which shows all SLAPPs from 2010 until 2023 in Europe. Unfortunately, they continue to rise year on year, with now more than 1,000 cases identified in 41 countries across Europe, which I think really shows that it's not a problem for a few member states. It's really widely spread across Europe. In 2023, specifically, a notable number of SLAPPs were mapped in Italy, over 26, which is a lot, Romania, Serbia, and Turkey. The majority of cases that were filed were civil lawsuits, more than 60%, and more than 20% were criminal lawsuits. Often, these lawsuits are based on national defamation laws or similar kind of provisions. Next slide, please. Journalists in their individual capacity remain the most likely target of SLAPPs, but also media outlets, editors, activists, and NGOs. There are other likely defendants, which include lawyers, academics, politicians, writers, and publishers. We saw that the people who file SLAPPs the most are businesses or business persons, followed by politicians, with quite a high number, over 35%, which is very concerning. And out of the cases that we recorded between 2010 and 2023, only 9.4% were cross-border cases, which is based on the narrowest definition of cross-border, so meaning that the plaintiff and the defendant are living in different countries. This is quite important when it comes also to the EU Anti-SLAPP Directive and the Council of Europe recommendation, as this has been quite a disputed subject in terms of what anti-SLAPP legislation should look like. At the moment, the EU directive does adopt quite a broad definition of cross-border, meaning that it's not cross-border if there are no cross-border elements. So anything that makes it cross-border, be it that, for example, the plaintiff and defendant are indeed living in different countries, but also if the investigation has implications, or the topic of the SLAPP has implications for another member state, it's immediately cross-border. So it is quite a wide definition at the moment. So next slide, please. Now that we've set the scene a little bit about case and what, how many SLAPPs there actually are in Europe, I wanted to dive a little bit indeed into the EU Anti-SLAPP Directive, which was agreed upon in November 2023 and formally adopted in April 2024. In general, I think it is really a win for years-long advocacy of having concrete legal measures against SLAPPs and making sure that all EU member states need to have anti-SLAPP legislation in place. The transposition timeline for member states to adopt this kind of legislation is in the next 2 years. So by April 2026, all EU member states should have anti-SLAPP measures in place. However, it is important to place a bit of a side note there that these are really the minimum standards for anti-SLAPP legislation. And that is because some of these standards, they help in terms of protecting public watchdogs against SLAPPs, but we believe that more is necessary to really provide effective protection. The EU Anti-SLAPP Directive has 3 main points which I wanted to highlight. The first thing is that the EU Anti-SLAPP Directive is only for cross-border civil SLAPP cases. As I said before, this cross-border definition is quite broad, so it does, like, a lot falls under that, but it still is cross-border cases. And it's also only regarding civil lawsuits. So the EU Anti-SLAPP Directive is not for criminal SLAPP cases, which we earlier saw constitutes about 20% of all SLAPP cases, which is still a significant number. Secondly, the EU Anti-SLAPP Directive outlines an early dismissal mechanism for SLAPP cases, but it is important to note that this early dismissal mechanism is only for manifestly unfounded cases. So in the EU Anti-SLAPP Directive, a distinction is made between manifestly unfounded cases on the one hand and abusive court proceedings. So this dichotomy is made. And for the early dismissal mechanism, it only applies for those manifestly unfounded cases, which means that in practice, the early dismissal mechanism is only for the most extreme cases and not for abusive cases, which are still incredibly harmful. In addition, it is said that the early dismissal needs to be treated in an accelerated manner, which we're very happy about, but the dismissal is not automatic. So member states can still choose not to dismiss cases, even though they're found manifestly unfounded. And then thirdly, there's a paragraph or an article there about compensatory damages. In this article, it's mainly outlined that SLAPP targets should get a full award of costs if a case is found to be a SLAPP. So that means that your full legal representation needs to be covered, all of those costs. And there are also possible measures to deter slappers or repeat slappers, for example. But unfortunately, the directive does not outline any compensation of damages, other damages that were incurred because of SLAPP cases. So that is in a nutshell the EU Anti-SLAPP Directive.
Thank you, Emma. Yes, as always, the devil is in the details, which is why I would like you to tell us if, by any chance, there is any complementary measures that comes up to help, in this case, in the Council of Europe recommendations, which was approved. Well, first of all, it covers broader states rather than the EU, but also it was approved more or less at the same time as when the directive was finalized. Is there anything that can help in this sense? Any loopholes that are filled by the recommendation?
Yeah, definitely. I think the tricky part is that the EU Anti-SLAPP Directive is the only legally binding instrument that member states have to comply with. So they have to transpose the directive. They do not have to transpose the Council of Europe recommendation. But we, of course, strongly recommend it and are very actively advocating for it. If we could go to the next slide. And that is because the Council of Europe recommendation really sets a lot more robust and comprehensive standards that really limit the damage caused by SLAPPs and provide a much more effective protection mechanism than the EU directive does. And I just wanted to highlight a few of these which are really important according to case. The first thing is that the Council of Europe recommendation covers all types of SLAPP cases. So it doesn't just cover civil cases or cross-border cases. It covers all domestic cases, all criminal cases, administrative cases. So the entire package of where you can start a SLAPP. And we believe this is really important for good anti-SLAPP legislation on the national level. Secondly, in the European directive, there is a little bit of language on how to identify a SLAPP, but it remains very vague, also because of this dichotomy between manifestly unfounded and abusive. And the Council of Europe recommendation is really helpful in that it has a very long list of SLAPP indicators, which could be helpful in assisting courts and national authorities in identifying SLAPP cases and when you can consider something a SLAPP. So this could be incredibly helpful for national courts. The third aspect is that it really pushes member states to ensure an early dismissal mechanism, not just for manifestly unfounded cases, but also for abusive lawsuits, which is an important addition. A fourth one, which we heavily advocated for the EU Anti-SLAPP directive, but unfortunately was taken out on the article of early dismissal, is a stay of proceedings, meaning that if you apply for an early dismissal of a case because it's a SLAPP lawsuit, that all proceedings are paused, meaning also that you don't incur any additional costs during the process. Unfortunately, this was taken out in the EU Anti-SLAPP directive, but it is there in the recommendation. And we believe this is super important because, yeah, it really makes sure that especially the financial implications of a SLAPP lawsuit are limited when you apply for an early dismissal mechanism. And fifth is that there is a full compensation of damages included in the Council of Europe recommendation, which is also really important to make sure that SLAPP targets are not just compensated for the legal representation, but also for all the other implications that it has. So it has an effect on your psychological well-being, has an effect on your being able to conduct any further work. And in the Council of Europe recommendation, that really accounts for it.
Thank you. So given that the directive is a minimum standards instrument and therefore the states can do more and should do more, and the Council of Europe recommendation seems to point to this direction by broadening the scope for protection and even for the very definition of abusive claims, for instance, if you had to move into the advocacy at national level, so what the states should do for strong, effective anti-SLAPP measures at national level, what would be the indicators for a good anti-SLAPP law, in your opinion, or based on your research as well?
Yes. So I think from these two aspects we have developed, the directive and the Council of Europe recommendation, Case Coalition has developed several standards that we believe would be really important in national legislation. I'll go through it quickly also for the sake of time, and we've already discussed them a little bit. But the first one is that it should have a broad scope to also cover domestic SLAPP cases and claims covered by criminal procedural law or administrative procedures. And actually for the case of the Netherlands, we've been coming across several cases, most cases are actually purely domestic, which would be very odd if there was a case where one media outlet maybe does fall under the SLAPP directive because maybe they collaborated with an international media outlet, for example, and then another media republishes that and doesn't fall under these same protection mechanisms just because they weren't part of that initial collaboration. So I think it's really important that we, on the national level, have those measures in place, not just for cross-border, but also for domestic and also for criminal and administrative procedures. Secondly, there should be really robust guarantees in terms of the early dismissal mechanism to filter out SLAPPs that doesn't just account for manifestly unfounded, but also abusive lawsuits, and ideally with the stay of proceedings. There should be safeguards in national legislation on damage compensation, which has specific criteria and also imposes like significant fines when you do use SLAPPs to really deter slappies from slapping public watchdogs. And I think the fourth one, which is also important to mention, there is a legal framework, and I think that's incredibly important, but there should also really be non-legal instruments, and that's worked out quite well in the European Commission's recommendation, but also the Council of Europe recommendation, so that there should be support mechanisms available. There should be awareness about raising about SLAPPs. There should be training of judges and lawyers. There should be data gathering and monitoring of SLAPP cases in national member states. So aside from that legal instrument, there should also really be an effort to work on non-legal support measures. I just want to end with the fact that the Case Coalition is setting up a transposition monitor, which will be launched soon, that will look at both European Union member states, but also Council of Europe member states in tracking how far they've been transposing not just the directive, but also the Council of Europe recommendation, so that we can really keep up our advocacy on the national level to make sure that member states, transpose comprehensive anti-SLAPP measures. Thank you.
Thank you so much, Emma. This is fantastic news. I mean, it's really great to highlight what hopefully will also be good practice of implementation. I was inadvertently muted. And I see that we have a question, a general question in the chat. Perhaps I can read it directly myself. It's from Kevin Keith. So general questions, SLAPPs are a real problem in the UK. Existing provisions in the Economic Crime and Corporate Transparency Act 2023 are deemed inadequate. And despite media support, progress is slow. I wonder about the importance of public awareness. If more people were aware of how the powerful people weaponize the law, then this could quicken the pace of change. What lessons are there across Europe about engaging the wider mass public on SLAPPs so as to influence positive change? I believe we will also hear from Jessica about the UK, but in the meantime, Emma, if you want to give a perspective, especially regarding the awareness raising at European level.
Yeah, I think it's a really great question and something that we've been struggling with quite a bit also for the Netherlands specifically. I think one of the issues is also that journalists are the main target of SLAPP lawsuits, but also journalism is coming under more and more fire. Also from politicians, for example, using language about journalists not being independent, spreading fake news, for example. So sometimes it's quite difficult to get public support for journalists. Currently, we see that very strongly in the Netherlands, for example. And we think it could really help to broaden, to show how SLAPPs affect civil society at large and our community and our society at large, I think. Because SLAPPs also affect, for example, victims of sexual violence. That's something we've been seeing more and more in the Case Coalition, is that victims of sexual violence who expose, for example, the perpetrators, or with Me Too cases, they also get SLAPPed, for example, or environmental activists, people who demonstrate, anyone basically at the moment could get SLAPPed. And I think it's really important to get that across to the wider public, to show that it's not just a problem of a few activistic civil society organizations or a few journalists, but it is a problem that can affect us all. And in the end also has an effect on democracy as a whole and society at large.
Thank you. That's so true. And thank you also for giving us this outline of what we need in order to have strong measures, effective anti-SLAPP measure at national level, which I think is the perfect segue to our next sessions, where we would like to talk about national examples of laws or advocacy for laws and trends of SLAPPs in countries. So we have invited, Jessica Mhainín, sorry, I have slaughtered your surname, from Index on Censorship, and who is the head of policy and campaigns. And she's co-founder of the UK Anti-SLAPP Coalition, and has also been actively involved in anti-SLAPP campaigns in Europe as a member of CASE. And currently she's also a member of the UK government's SLAPP task force. So welcome, Jessica, and thank you for joining us again. Can you tell us about the use of SLAPPs, specifically in the UK, as a tool for silencing public interest speech? And how have you been advocating for effective anti-SLAPP legislation in the UK? The floor is yours, Jessica.
Thank you so much, Francesca. Yeah, so I have some slides here as well, which I hope to be able to help illustrate this complex problem, as has been well established by now. So in the UK, SLAPPs are manifesting themselves. I'm going to move on to the next slide, where you can see some of the the legal vehicles. Sometimes we allude to them as that are used to direct SLAPPs at individuals, and a variety of legislative vehicles, from data protection, harassment, copyright, malicious falsehood. The use of privacy has been increasing, but defamation continues to be used most frequently. Because, as we know, since SLAPPs are an abuse of the law, the individual who is trying to silence will use any means basically at their disposal in order to target the individual. And the other important thing to note about SLAPPs is that it gives this harassment kind of an air of legitimacy as well, because it's being used through the legal system and using lawyers and as the enablers in that. So, as I say, those are some of the ways that they manifest themselves. And one of the first things that happens when you become the target of a SLAPP is a letter. You usually get a letter. So here is an example of a typical legal letter that would be sent by a law firm to someone who is being targeted by an abusive legal threat. So you can see some of the language that is used here. It's threatening, it cites very high damages, it might threaten litigation in another jurisdiction sometimes. It's warning the recipient that the contents of the letter are confidential, so that the individual in question may feel that they can't reach out to someone else for support for fear of violating that confidentiality. These are just some of the tactics that we would regularly see used in SLAPP letters. Now, this particular letter was sent to all sitting members of Parliament in the UK last year as part of, sorry, I'm still on the previous slide, as part of the UK Anti-SLAPP coalition campaigning efforts. Its aim was to try to illustrate to MPs the nature of the legal harassment targeting public watchdogs in the UK, just to try to give them a small sense of what it feels like to get a letter like this. Now, of course, these MPs could get comfort in the fact that this letter is not real. It was, however, drafted with the input of media defence lawyers who have regular first-hand experience of seeing these kinds of letters, so it's not an unrealistic example. Now, the law firm is entirely fictitious. If you are paying special attention, you'll actually notice that the acronym of the law firm actually spells out SLAPPs. And if the MP decided to click through to the law firm's website, it would just redirect to the website of the UK Anti-SLAPP Coalition. And I'm actually going to put the UK Anti-SLAPP Coalition's website in the chat there, for those who would like to have a closer look. So yeah, they would have realized pretty quickly that it's not a real legal letter, but unfortunately those who really are targeted with these letters don't get that kind of comfort, and letters like this keep on coming. So on to the next slide then. SLAPPs, it's really important to note as well, they mostly stay within the litigation process. That is the back and forth of legal letters. And after receiving a letter or maybe two letters like that, many SLAPP targets will decide to back down pretty quickly because of that really chilling, that really intimidating effect that these letters with such harsh language very often have. So there's a huge incentive as well for the legal actions not to go to court, because the combination of legal costs, fees, and the potential damages that can run into thousands, if not millions of pounds. And this is especially true in the UK, where the cost of this kind of litigation is particularly well documented. And that those costs say nothing of the time associated with defending the case, for which individuals or freelancers, which applies to two of the case studies that you can see here on the slides. That means that it's also costing them earnings, because they'll need to take time off work to defend their case. So it's really hitting them on all sides, and they really can't afford to keep going with it in many cases, even if they know what they said was true. So that was the example here. So the first case is Reality. This was mentioned in the case studies as well at the beginning. This was a small finance and business publication in Sweden. And in about 2019, two of their freelance journalists began investigating a business belonging to a Swedish businessman. the journalists started receiving legal communication from London, even though they were in Sweden, after they sent some questions as part of their investigation. Now, they were publishing in the Swedish language for a Swedish audience, but they were sued as individuals along with their editor and their publication in London. They contacted us in the UK Anti-SLAPP Coalition because they were really incredulous. They had consistently maintained that they'd done nothing wrong, yet they were now at risk of basically losing their homes as a result of the legal action. The action was eventually settled in January 2023. The journalists would have actually preferred to go to trial and to really defend the case to the end, but the costs were just absolutely crippling. They were too great. So at the time that the case was filed against Reality, the UK was still a member of the EU and party to the Lugano Convention, which meant that at that stage it was more straightforward to bring cases against defendants domiciled in states parties to the convention, so the UK. Now, when the Brexit transition period ended in December 2020, the UK was no longer subject to the Lugano Convention, so now UK courts would have to rule on the appropriateness of EU-based claims bringing action in the UK. So maybe that's a small silver lining to Brexit, that EU-based journalists can't get sued with the same ease in the UK as they previously were. Yes, then the second example is one that Emma, you had mentioned as well. We are seeing a growth, or not even really a growth in cases, but more people possibly speaking out against these kind of Me Too cases. And this is an example in the UK against a survivor of sexual and gender-based violence called Nina Cresswell. She posted on social media about her experience of sexual assault in an effort to warn other women about the perpetrator, who was a tattooist who she believed would have had regular access to women's bodies as a result of his profession. So she tried to warn other women, as I say, and she faced a legal action from that man, from that individual, the person who had sexually assaulted her. The case did actually go all the way to trial. She got some support in order to take the case to trial, and she successfully defended her case in April 2023. It was a landmark case because she won it on the truth defense, so the judge agreed that what she said was true and that it was in the public interest. So it was an incredible victory, but it came at a huge personal, not to mention financial cost. You know, for a survivor of sexual and gender-based violence to have to come up against your abuser in court, and for you to be on the witness trial, it's a really traumatic. I think we can't, underestimate that. It's a really horrible and traumatic experience that no survivor should ever have to go through. Of course, anti-SLAPP legislation, we hope, would prevent that from happening. The third case here that I want to mention, because it's so important to highlight environmental defenders, and of course Greenpeace, as we know, has long been a target of SLAPPs. And last year they were sued by Shell in the UK in relation to a protest they had carried out on a production platform. Shell had initially threatened to sue Greenpeace for more than $8 million, or £6.5 million in damages, before reducing the claim to £750,000 in damages. The prohibitive cost, again, of defending the legal action influenced Greenpeace's decision to settle in December 2024. So these are just a few examples in some small detail, and they're all from England and Wales, all based in London, but there are other cases which you can find on the UK Anti-SLAPP Coalition website. So then, looking at what anti-SLAPP legislation is in place in the UK, maybe we can move on to the next slide, and then the next one again. It's for the purposes of SLAPPs, there are actually 3 legal systems in the UK, because this is what's known as a devolved matter. The England, England and Wales, and then Scotland and Northern Ireland each need to enact their own anti-SLAPP legislation. So firstly, in England and Wales, it's of course the biggest of the 3 legal systems, and it also happens to be a SLAPP hotspot, not only within the UK, but within the world. So that has been our main focus when it comes to getting some anti-SLAPP legislation over the line. The Economic Crime and Corporate Transparency Act has just already been mentioned a short while ago, and in 2023 we managed to secure an anti-SLAPP amendment to the bill. That was a bill that was already going through Parliament, and that bill became an act, it became law in November 2023. However, the legislation is limited to stopping SLAPPs related to public interest speech specifically on economic crime. So of the two previous examples, this anti-SLAPP legislation would be perfectly useless in protecting the individuals targeted. We also have some other issues with that legislation, including its lack of any meaningful compensation for the defendant or punishment of the claimant, which are so important. And this legislation is actually now, while it came into force, when it was made an act in November 23, it's taken some time, so it's actually due to come into force officially this month. So we haven't seen it, being actually put into effect yet, being used. So then in Scotland,
I'm sorry, for the sake of time, it is all very, very interesting, but we are running out of time, and I would like to ask you if you could maybe wrap up focusing on your advocacy actions towards maybe implementation of these legislations or anything else that they are doing in the UK to stop SLAPPs. I'm sorry to barge in.
Sure, I just mentioned an important note then here, which is that there is a consultation on SLAPPs that's currently open in Scotland at the moment that might be of interest to people. So yeah, and that was the other main part to mention here. Yeah, so then in terms of
sorry, in the chat link to the consultation or something like that later or now. Yeah,
we can do that. Great. So yes, unfortunately, I mean, we continue to do a lot of a lot of work to forward anti-SLAPP legislation in the UK, but unfortunately, in the short term, it looks unlikely that we'll be successful in getting legislation over the line. And I'd move on to the next slide, given that the government has basically confirmed that they don't intend to legislate during this parliamentary session. This is disappointing, but we hope they will reconsider when they soon see how lackluster the ECTA will be at protecting public interest speech. And in the meantime, we'll be focusing on some other key areas of our anti-SLAPP work. And on the next slide, we can see what some of these are. So visibility is really important. So as I think it was Keith who mentioned in the SLAPP before, we are in the chat rather, we need to really increase visibility, public awareness of SLAPPs. And that includes, I think it was reflected well in the poll at the beginning, to show that there's a range of cases, not just those against journalists. There's a range of public watchdogs that are targeted, including, any one of us can be subject to SLAPPs. I think in our public awareness building, that's something that we need to make clear. Anyone speaking out in the public interest can be targeted. Secondly, we need to really support targets of SLAPPs, build solidarity, build a network around them, a network of support, which is really important. Thirdly, we need robust regulation. That's something that we've had some success with in the UK, in that the Solicitors Regulation Authority in London has brought in regulation through a warning notice issued to solicitors to prevent them, to advise them against engaging in this practice, because solicitors, lawyers, they are the enablers of SLAPP. So we really want to stop them from engaging in this abusive process, in this malpractice. And fourthly, of course, legislation. So we will be continuing to advocate for a legislative response to SLAPPs. But it's really about, I think, as Emma said as well, having a really broad, a broad scope to approaching this, and not just looking squarely at legislation. We need a really well-rounded approach. And on the UK Anti-SLAPP Coalition website, you're very welcome to sign up to our newsletter, where you can follow, hopefully, our positive steps towards targeting SLAPPs in the coming weeks and months.
Thank you so much, Jessica, for your very thorough overlook of the situation in the UK. And now we would like to quickly move on to the situation in Poland, which is actually, hopefully, we will be a bit more positive. We end up on a positive note, because we have with us Zuzanna Nowicka, from a lawyer with the Freedom of Speech program at the Helsinki Foundation for Human Rights in Poland. She has also been actively combating SLAPPs. And she's also the author of several publications on the subject, including an opinion on the draft Polish law implementing the Anti-SLAPP Directive. And she's also an academic pursuing her PhD. in the field of freedom of expression and SLAPPs. And speaking of your publications, indeed, Zuzanna, you wrote a very interesting blog last year, whose title is From Zero to Hero, in which you argue that Poland has actually moved on from being a country with one of the highest numbers of SLAPPs in Europe to being a model for how to successfully fight them. So I think, I mean, we're all very curious to hear how this happened and what is the recipe for success. The floor is to you.
Thank you so much. I have to probably begin with a disclaimer. So the blog post you mentioned was co-written by me and Dominika Bychawska-Śniarska, who is probably known to many of you. And the enthusiastic tone of the blog, as well as the title, was meant to encourage the current government to propose many changes and take up legislative action. So today I will mention the same title, maybe with the tongue in my cheek a bit, and show what actually has been done and what hasn't. But to answer directly a question, like what is, according to us, the recipe for success? The answer is very sad. It's the change of the government. Literally, most of the changes that took place regarding to freedom of expression in Poland, that was thanks to the Law and Justice party losing the parliamentary elections more than a year ago. But to be more concrete, I have to mention two aspects. One was something that was not dependent of us, and it's the fact that the new Minister of Justice, Adam Bodnar, has a very strong human rights background. He used to be Polish ombudsman. He actually, currently at my office at Helsinki Foundation of Human Rights and the Freedom of Speech program, he used to sit here because he was working on the very same program some time ago. So that's why I think he was very, very receptive when it comes to our arguments. But the second one was that we at a very early stage, we formed a coalition, like a working group in Poland, Coalition Against SLAPPs, let's say, of different organizations, and every single action that we take together. Maybe not every single, but definitely most of them. And also we did take on board a lot of people from the media world. So when we did publish an opinion on the draft legislation, it was regarding criminal defamation. It was on the first page of Gazeta Wyborcza, which is one of the most important newspapers in Poland. But jumping into my presentation, what I wanted to do today with you is to show you at the beginning how the situation with SLAPPs looked like under the previous government and how it looks like now. I chose to show you just the most stark examples that I believe very well illustrate how it looked like under the Law and Justice, and I mean the period between 2015 and 2023, but that's mostly the later years when SLAPPs became popular. So, for example, Zbigniew Ziobro, who then used to be the Minister of Justice, and he also was he was also the Prosecutor General, because these functions were not yet they're separate. But ex officio, of course, the Minister of Justice is also the Prosecutor General. And there was an example when he initiated 3 separate proceedings related to the same article, each in a different capacity. So this is when you try to, like, I think a very, very stark example of trying to intimidate your legal opponent. There were a lot of SLAPP cases initiated by people connected to the Minister of Justice, vice deputy ministers, but also people connected somehow working for them, maybe. What was very also, I believe, showing how the government functioned was that they were using public money to cover the legal fees and also cover the legal expenses. When you mentioned that, Poland was one of the countries with the highest number of SLAPPs, I also just wanted to say that that's certainly true, but also there's a silver lining. Poland ranked as a country with a high number of SLAPPs because Gazeta Wyborcza was very transparent about how the legal attacks they faced. So maybe some other country even scored higher, but we just never got the data. But yes, it's absolutely unprecedented number of SLAPPs and legal threats as well. As of 2024, we're talking around 150, 140 cases in a very short period of time. As of 2024, 80 of the cases have been concluded and 60 are still pending. Obviously, the Gazeta Wyborcza won most of these cases. The courts ruled that they did what they were very objective and did the best as they could in covering public news. What I also wanted to mention is that SLAPPs were just one of the instruments that were used to silence independent media. And also what's, I think, crucial is that there was a lot of the SLAPP cases were initiated over minor matters. So what we are, I believe, used to is that it was an article that was, I don't know, on front page news tackling a very important public subject. But in Poland, we also saw Lasy Państwowe, which is the national forest, suing an activist, or a state-owned gas company also suing a 20-year-old activist over projecting text under the building of their company. So this was also a very important issue. To go further, what happened after 2024, when the current government, the civil coalition won the parliamentary election, is that, first of all, definitely the number of cases initiated by Law and Justice declined. Probably, this is my guess, there's no data to back this, but I believe that might be because of the lack of the sources. As I mentioned, they use public money to fund their legal fees and legal representation. So probably now that they are no longer have access to that money, and they're also struggling economically for different reasons, that's probably why the number of cases declined. What's really positive is that under the current ruling coalition, we noticed a significant decrease in the use of SLAPPs by the central government once the people who are in power changed. There are, maybe I will talk about that later. So it's even hard to compare. So it's the numbers were extremely high. Now they are extremely low and very low, although there are some. I will talk about this later. And also what's important is that some legal actions, and particularly those initiated by state-owned companies, have been dropped. And now what I have in mind is one criminal case initiated against the activists initiated by state forests, but also we have this very interesting case of a Horeca connected a person who covered the issue of the Law and Justice party using wiretapping state-owned hotels, and the company, state-owned company owning the hotels, dropped the lawsuit after the Law and Justice lost the elections. Also, what was really positive was that the Minister of Justice promised the decriminalization of defamation. And this is in Poland, a private party can initiate criminal proceedings. There is no need for the law officials enforcement officials to engage in that action. So for this reason, we believe that this is still a SLAPP, even though it's criminal proceedings. And also the draft law implementing the Anti-SLAPP Directive has been presented. With the good news regarding the draft law is that it applies to both national and transnational cases. What I have in mind right now is the statistics regarding statistics showing that most of the cases actually have national characters. And not to talk for too long, here's the tongue in a cheek. So I believe personally that we are still waiting for the hero. So anyway, there are still some threats of initiating SLAPP-like cases. After sending this slide to Carina, I did deepen my research and realized that there is, I think, at least one SLAPP case that we can consider as initiated by someone who's connected to the government, the current government. So Roman Giertych, someone who's very close to the ruling party, for example, sent out some threads on X. So this is still something that we see. Some proceedings aimed at silencing individuals that were initiated by state-owned companies are still ongoing, and they could have been dropped. Most of them are baseless, but they are not. And also what the Criminal Codification Commission has presented a draft regarding the Article 2012 criminalizing defamation, which we were hoping is going to fulfill the Ministers of Justice promise to decriminalize defamation. It did not. It only modifies the law, and in my personal view, but also the view of Helsinki Foundation, these proposed changes are actually unlikely to have a significant impact on the practice of application of that criminal provision. And the last thing I wanted to mention is the draft law. I would give it a B+. So there are some issues. For example, it does lack several key provisions, including the reversal of burden of proof and, for example, the protection against third-party judgments. We are currently in the process of the minister is going to further work on that project, and some of the things that are lacking maybe are not necessarily need certain another concrete provision to be introduced. Maybe that is not necessary. So we will see how this goes.
Thank you so much. So just to wrap up, I would say from what we have heard that we could reasonably conclude that SLAPPs are a far more complex issue than they look, and there still need to be a lot of understanding, awareness raising, especially working on changing the narrative to make people understand that it's not just about journalists or media, but it's about civil society as such. And of course, there are some encouraging signs, like in the case of Poland, but we need to keep our guard up because there's still a lot of work to be done in terms of implementation of good standards. So with that in mind, I would like to, I know there's only 10 minutes left, but briefly pass the baton over to Tim Hughes that is going to guide us on what is the next step. What do we do now? Thank you so much.
Fantastic. Thank you very much, Francesca, and thank you to all of our speakers. I've certainly learnt a lot over the past hour or so. And as Francesca says, we want to spend just a few minutes thinking about the way forward from here, and particularly in the context of OGP as well. So as we've heard about, civic space, media freedom are really key kind of fundamental topics to open government. You can't have open government without them. And at the same time, OGP, so the Open Government Partnership, we think provides a good platform for government and civil society to work together jointly towards reforms to increase civic space and media freedom. You can see on the map that's on the screen at the moment that quite a large number of countries during OGP's kind of almost 15-year history now have done so. So 48 countries in total have made civic space commitments across 102 open government action plans and 143 commitments in total. So this is an important and kind of growing area of work for us. But when we look at freedom of expression, the numbers are sadly much lower at the moment. So this is an area that we really want to encourage our members in OGP to work further towards. So you can see the graph here over time since 2012 of kind of percentage of members each year who have made a commitment on freedom of expression in their open government action plan. And I guess it's kind of peaked at kind of 12 or 13% some years, but then other years it's been as low as kind of 3 or 4%. So again, an area that we really want to encourage countries to focus more around. I think one country to particularly to call out here is Slovakia, who have made a commitment linked to the EU directive on SLAPPs, which looks at kind of implementation of that directive. This is something we want to encourage all of you to think about for your own countries, whether you could use your OGP process as a way for government and civil society to work towards implementation of the directive, but also kind of, as we've heard, hopefully going above and beyond what's in the directive towards the recommendations from the Council of Europe and the other sorts of recommendations that we've heard today. And in thinking about that, kind of one additional thing to be aware of that many of you will hopefully have seen already is the OpenGov Challenge that we launched back at the OGP Global Summit in Estonia about a year and a half ago now. And here, the OGP Steering Committee set the challenge for the partnership to work towards these 10 areas and introduce specific kind of ambitious reforms on these 10 challenge areas. And the one on media freedom is very relevant to what we've been discussing today. And indeed, you can see the first bullet point in terms of kind of actions and reforms that can help to address that challenge includes removing criminal defamation, libel, and other penalties for reporting and tackling the use of SLAPPs to silence journalists and activists. So we are continuously kind of accepting challenge submissions, but an important date for you to be aware of is the end of May. We have launched recently the OpenGov Awards. That will be kind of showcased at the OGP Spain Summit in October. And there is a cut-off point of the end of May for countries to make their submissions to the OpenGov Challenge for them to be included in the OpenGov Awards. So particularly over the next couple of months, we hope that you might kind of take this opportunity and use this as a way to kind of advance your own national reforms, but then also be part of this wider global effort as well. So final thing we wanted to do quickly is one final poll, just to get a sense of where conversations are at in your countries at the moment. So this will pop up on the screen in a second. So the question is, how likely is it that legislative anti-SLAPP measures are explored in your national context? And 4 different options. So already under active discussion outside of your OGP process, already under active discussion within your OGP process, and then somewhat likely or not likely. So let's give you a few seconds just to do that now. And then wonder when we've got enough people, you can close it and we'll see the result. Okay, so somewhat likely has come out on top with 45%, and then it's a three-way tie for the other 3 options. So 18% already under active discussion outside of OGP, 18% under active discussion within OGP, and 18% not likely. So hopefully we can kind of translate some of those somewhat like these into some more active discussions, and yeah, hopefully you can make the use of both your OGP action plan processes and the OpenGov Challenge to really kind of forge ahead on this important topic. So I think that brings us to a close. I want to say another really big thank you to all of our presenters today for your excellent informative presentations. Thank you to all of the attendees as well. There are lots of links in the chat that are worth having a look at as well on each of these different items. And you will also find this recording on YouTube after as well. So if you want to watch it back, you have the opportunity to do so. Thank you all very much for joining, and yeah, look forward to seeing progress on this topic in the future.